Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. We will learn about the evolution of sedition as a penal law today, which happens to be an extremely important topic. Objectives of the present module are, firstly, to explain the meaning and scope of the term sedition. Then, to trace out the genesis and development of the concept of sedition. Also, to find out the origin and development of the law of sedition in India. Lastly, to discuss the recommendations of the Law Commission of India on sedition. Now, my dear learners, before the detailed discussion, let's have a brief overview of the topic. Sedition is not defined in section 124A of Indian Penal Code, but is found in the marginal note to the section. It is a misdemeanor at common law consisting of acts done, words spoken and published, or writings capable of being a libel published. In each case, with an intention to bring into hatred or contempt, or to excite disaffection against the Queen or the government and Constitution of the United Kingdom, or either House of the Parliament or the administration of justice, or to excite the Queen's subject to attempt otherwise than by lawful means the alteration of any matter in church or state by law established, or to incite a person to commit a crime in general disturbance of the peace, or to raise discontent or disaffection amongst Her Majesty's subjects, or to promote feelings of ill will and hostility between different classes of those subjects. This was observed in the famous case of R versus M. Hugh of 1901. Now, dear learners, as regards the genesis and development of the concept of sedition, the origin of the law on sedition can be traced back to the English law. Sedition laws were enacted in 17th century England, when lawmakers believed that only good opinions of the government should survive, as bad opinions were detrimental to the government and monarchy. In feudal England, sedition comprised those libels and slanders that would alienate the rulers from their subjects. Traditionally, the legal elements of sedition were obscure and thus failed to provide a precise definition. The offences which would now be classified as sedition were prosecuted under treason or under scandalum magnatum or even under martial law. From their inception, laws suppressing dissent have been political in nature. The earliest known such decree was under the First Statute of Westminster 1275, which came into being as a direct outcome of a rebellion of the barons against the monarch, who was considered the holder of the divine right. This was aimed at safeguarding the ruling establishment, including the nobility, from popular uprisings that challenged the existing order. The doctrine of scandalum magnatum, a Latin term for scandal of the magnates, became the basis for this law, which placed curbs on scandalizing or criticizing royalty, judges, or peers. Over the subsequent centuries, this made its journey through statutes of treason, 1352 and 1534, and evolved into the offence of seditious libel in 1606 as a Star Chamber decision in De Libelis Famosus, the law of libel or written defamation. In this case, the court held that criticism of public officials and the government would inculcate disrespect for public authority. Interestingly, this case evaded some of the safeguards laid down in the offences of treason and scandalum magnatum. The 18th century saw the increased usage of sedition against the printed word. It continued to be part of the English law until it was abolished in the new millennium. So far as the origin and development of the law of sedition in India is concerned, the law was originally drafted in 1837 by Thomas Macaulay, the British historian politician, but was omitted when the Indian Penal Code was enacted in 1860. Section 124A was inserted in 1870 by an amendment introduced by Sir James Stephen, when it felt the need for a specific section to deal with the offence. Today, the sedition is a crime under Section 124A of the Indian Penal Code. The sedition law in its present form owes its origin to the 1830s, when codification of Indian laws started. Prior to codification of Indian laws, they were a complex array of parliamentary charters and Act, East India Company regulations, English common law, Hindu law, Muslim law, and many bodies of customary law. The draft Indian Penal Code 1837 by Thomas Babington Macaulay included a section on sedition. This draft section 113 was similar in its framing to the current section 124A of the Indian Penal Code. The punishment proposed was life imprisonment. However, the section was not included in the Indian Penal Code when it was enacted in 1860 due to what was subsequently attributed to an oversight. Section 124A, which criminalizes disaffection towards the government established by law or sedition, was finally introduced through an amendment in 1870 by the then law member of the Governor-General's Council, James Stephen. Macaulay's draft penal code provided for a clause which incorporated the offence of sedition as follows. Section 113 provided, whoever by words either spoken or intended to be read or by signs or visible representations attempts to excite feelings of disaffection to the government established by law in the territories of the East India Company among any class of people who live under that government shall be punished with banishment for life or for any term from the territories of the East India Company to which fine may be added, or with simple imprisonment for a term which may extend to 3 years, to which fine may be added, or with fine. As per the explanation, such a disapprobation of the measures of the government as is compatible with a disposition to render obedience to the lawful authority of the government against unlawful attempts to subvert or resist that authority is not disaffection. Therefore, the making of the comments on the measures of the government with the intention of exciting only this species of disapprobation is not an offence within this clause. Sir John Romilly, the chairman of the second pre-independence Law Commission, commented upon the quantum of the punishment proposed for sedition on the ground that in England the maximum punishment had been 3 years, thereby suggesting that in India it should not be more than 5 years. The first case to be tried under the law of sedition in India was 20 years after its introduction in IPC. The case was Queen Empress versus Jogendra Chandra Bose, 1891. The proprietor, editor, manager and printer of the Bengali magazine Bangobasi was tried under the law for publishing an article criticizing the British government's Age of Consent Act that raised the age of consent for sexual intercourse. In this case, however, there was no conviction. The jury could not come up with a unanimous verdict. W. Komar Patharam, Chief Justice of Calcutta High Court, said that he would not take any verdict that was not unanimous in this case. And finally, Bose was let out on bail. Section 124A. This section of IPC provides that whoever by words either spoken or written, or by signs, or by visible representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, he shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. Explanation 1 provides that the expression disaffection includes disloyalty and all feelings of enmity. Further, as per explanation 2, comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means, without exciting or attempting to excite hatred, contempt or disaffection, do not constitute an offence under this section. Explanation 3 provides that comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offence under this section. Now let's discuss the punishment for the offence of sedition. My dear learners, it is a non-bailable offence. As discussed earlier, the punishment under section 124A ranges from imprisonment up to 3 years to a life term, to which a fine may be added. A person charged under this law is barred from a government job. They have to live without their passport and must produce themselves in the court at all times as and when required. Now, we will understand the scope and ambit of the section. The offence of sedition is the resultant of the balancing of two contending forces, namely freedom and security in their pure form are antagonistic poles. One pole represents the interest of the individual in being afforded the maximum right of self-assertion, free from governmental and other interference, while the other represents the interest of politically organized society in its self-preservation. While conceding the imperative necessity of freedom of speech and expression in its full width and amplitude, it is necessary at the same time to remember that The first and most fundamental duty of every government is the preservation of order, since order is a condition precedent to all civilization and the advance of human happiness. The security of the state and organized government are the very foundation of freedom of speech and expression, which maintains the opportunity for free political discussion to the end that the government may be responsive to the will of the people. This balance has been achieved by the legislature in the enactment of Section 124A. Now, Law Commission in its 42nd report, 1971, provided that the issue of sedition was further considered in this report, titled Indian Penal Code, wherein the Commission undertook a holistic review of Section 124A. The Commission recommended that the elements mentioned in this article, which are relevant to the offence of sedition, are integrity of India, security of the state, and public order. The section has been found to be defective because pernicious tendency or intention underlying the seditious utterance has not been expressly related to the interests of integrity or security of India or of public order. Now, this defect should be removed by expressing the mens rea as intending or knowing it to be likely to endanger the integrity or security of India or of any state or to cause public disorder. The Commission highlighted another defect noticed in the definition of sedition, that it does not take into account disaffection towards the Constitution, the legislature, and the administration of justice, all of which would be as disastrous to the security of the state as disaffection towards the executive government. These aspects are rightly emphasized in defining sedition in other codes, and we feel that Section 124A should be revised to take them in. Moving further, the 267th report of the Law Commission of India on hate speech in the year 2017. The 267th report of the Law Commission on hate speech distinguished between sedition and hate speech, providing that the offence of hate speech affects the state indirectly by disturbing public tranquility, while sedition is directly an offence against the state. The report adds that to qualify as sedition, the impugned expression must threaten the sovereignty and integrity of India and the security of the state. Another important point is sedition vis-a-vis free speech. Free speech is a hallmark of democracy. The purpose of this freedom is to allow an individual to attain self-fulfillment, assist in the discovery of truth, strengthen the capacity of a person to take decisions, and facilitate a balance between stability and social change. It finds mention in the preamble and Article 19 of the Universal Declaration of Human Rights, 1948. However, reasonable restriction can always be imposed on this right in order to ensure its responsible exercise and to ensure that it is equally available to all citizens. According to Article 19, Clause 3 of the International Covenant on Civil and Political Rights, 1966, this freedom may be subjected to restrictions, provided they are prescribed by law and are necessary for respecting the rights or reputation of others, or for the protection of national security, public health, public morals, and public order. Now, what is the significance of the law on sedition? The relevance of the offence of sedition provided under section 124A of Indian Penal Code is a subject of continuous and ceaseless debate. Those opposing see this provision as a relic of India's colonial past. Colonial administrators used sedition to lock up people who criticized the British policies. Stalwarts of the freedom movement such as Lokmanya Tilak, Mahatma Gandhi, Jawaharlal Nehru, Bhagat Singh, etc. were convicted for their seditious speeches, writings and activities under British rule. Thus, rampant use of sedition law recalls the colonial era. The Constituent Assembly didn't agree to include sedition in the Constitution. The members felt it would curtail freedom of speech and expression. They argued that the sedition law can be turned into a weapon to suppress people's legitimate and constitutionally guaranteed right to protest. Supreme Court in Kedarnath Singh versus State of Bihar 1962 observed that limited application of sedition to acts involving intention or tendency to create disorder or disturbance of law and order or incitement to violence, thus invoking sedition charges against academicians, lawyers, socio-political activists and students in disregard of the Supreme Court's order. This law is also alleged to be used to suppress democratic values. On the other hand, it is argued that amidst growing concerns of national security, this provision provides a reasonable restriction on utterances that are inimical to the security and integrity of the country. The Constitution of India prescribes reasonable restrictions under Article 19, Clause 2 that can always be imposed on freedom of speech and expression in order to ensure its responsible exercise and to ensure that it is equally available to all citizens. Balancing freedom of expression with collective national interest is one of the key ingredients of this law. Indeed, dissent with the sole objective to unseat a government strengthens the democratic fabric, so long as it doesn't use mischievous propaganda of extreme form or lead to tendency of violence or disorder or support disintegration of the country. The purpose of sedition was not only to check the threat against the safety and stability of the state, but also to ensure that valid criticism of the government was not eclipsed at the same time. Sedition law helps the government in combating anti-national, secessionist and terrorist elements. It undoubtedly helps in protecting the stability of the elected government from attempts to overthrow the government with violence and illegal means. The continued existence of the government established by law is an essential condition of the stability of the state. Then what about the alleged misuse of section 124A of the Indian Penal Code? It is often alleged that section 124 of Indian Penal Code is misused by the governmental authorities to quell political dissent. The provision has invented stringent criticism on account of being invoked by various state governments against activists, detractors, writers, journalists, etc., seeking to silence political opposition by accusing the dissenters of promoting disaffection. One of the major grounds of objection to Section 124A is that a forceful censure of governmental policies and personalities and stinging denunciation of an unresponsive or insensitive administration are in all likelihood wrongfully treated to be seditious. Law Commission in its 279th Law Commission in its 279th report has observed that it is imperative to lay down certain procedural guidelines for curbing any misuse of Section 124A of IPC by the law enforcement authorities. Any allegation of misuse of this provision does not, by implication, warrant a call for its repeal. There are a plethora of examples of various laws being misused by ill-intentioned individuals only to settle their scores in cases of personal enmities and vested interest, with even the Supreme Court recognizing the same in a number of decisions. Never has there been any plausible demand to repeal any such laws, merely on the ground that they are being misused by a section of the populace. This is so because for every abuser of that law, there might be 10 other genuine victims of any offense who direly need the protection of such a law. What is then required in such cases is only to introduce legal ways and means to prevent the misuse of such a law. In a significant development, the Law Commission of India has recommended against the total repeal of sedition law, that is Section 124A of the Indian Penal Code, and has instead proposed that the provision be retained with certain amendments. In February 2021, the Supreme Court of India protected a political leader and 6 senior journalists from arrest for allegedly tweeting and sharing unverified news in multiple sedition FIRs registered against them. In June 2021, the Supreme Court, while protecting 2 Telugu news channels from coercive action by the Andhra Pradesh government, emphasized on defining the limits of sedition. Again, in July 2021, a petition was filed in the Supreme Court that sought a relook into the sedition law. The court ruled that a statute criminalizing expression based on unconstitutionally vague definitions of disaffection towards government, etc., is an unreasonable restriction on the fundamental right to freedom of expression guaranteed under Article 19, Clause 1, Subclause A, and causes constitutionally impermissible chilling effect on speech. Abolition of sedition in United Kingdom. The Law Commission of United Kingdom, in a working paper in 1977, scrutinized the sedition law and expressed its provisional view that there is no need for an offense of sedition in the criminal code. In 2009, the crime of seditious libel was abolished through the enactment of the Coroners and Justice Act 2009 in the United Kingdom. It is pertinent to note that in United States also, the law relating to sedition is very narrowly construed and can even said to have fallen in disuse. My dear learners, in conclusion, it can be said that Section 124A of the IPC has its utility in combating anti-national and terrorist elements. However, dissent and criticism of the government are essential ingredients of robust public debate in a vibrant democracy. They should not be constructed as sedition. The higher judiciary should use its supervisory powers to sensitize the magistracy and police to the constitutional provisions protecting free speech. The definition of sedition should be narrowed down to include only the issues pertaining to the territorial integrity of India as well as the sovereignty of the country. Then, civil society must take the lead to raise awareness about the arbitrary use of sedition law. My dear learners, I hope you find this lecture informative and beneficial. Thank you very much.